Hello, everyone, and welcome to Uncivil Law. For today's case, we have a controversy in the world of sports. What sport, you ask? Darts. Yes, darts. There is a controversy involving lies and defamation and jerseys and all kinds of stuff and paid promotions. It is so great. So we're going to learn about this controversy in the world of darts. That's the thing that's happening, so let's read this decision and get started. Turtine, a Missouri resident, is owner and president of Promotional Services, a Missouri corporation with a principal place of business in Missouri, which is the governing body for the sport of darts. Professional Services also operates a dart league and stages an annual darts tournament in Kansas City, Missouri, area called the Tournament of Champions for darts. Peterson, a Minnesota resident, is the managing member of Red Eye Rhino. Cute name because dartboards have a red middle part, the bullseye. Red Eye Rhino. A Minnesota LLC with a principal place of business in Minnesota, which sells dart-themed apparel and produces dart-related videos. Red Eye Rhino has a Facebook page that uses to promote its business. We definitely got to have to find that and put it in the link of the description or something. That's great. Defendant also has a Facebook page under the name of Charles RER, a moniker used to promote Red Eye Rhino. Promotional Services and Red Eye Rhino entered a contract under which Promotional Services granted Red Eye Rhino the right to be the exclusive jersey provider for the league, for the tournament. Exclusive jersey provider for the exciting world of darts. Good stuff. As part of this contract, Promotional Services sold Red Eye Rhino $7,500 worth of vouchers that entitled the holder to participate in the tournament. Very cool. In 2016, Promotional Services implemented a new apparel rule for its tournament, prohibiting players from wearing brands, such as Red Eye Rhino, unless the brand made a $500 donation to the National Pediatric Cancer Foundation. I'm not saying the National Pediatric Cancer Foundation is not a worthwhile charity. I just wonder why, of all the charities they could have picked, why the World of Darts went with that particular charity. Was there not a more dart-appropriate themed charity? But they went with pediatric cancer. So, okay, you have to make a $500 donation, or else people can't wear a brand on TV. All right. Promotional Services then informed Red Eye Rhino that it would not be given the right to make an exclusive jersey for the 2016 tournament, and Red Eye Rhino declined to make the required donation. There's a falling out between these companies. Exciting. Turntine nevertheless donated on Red Eye Rhino's behalf, so they could still wear Red Eye apparel. Pearson then published a new number of Facebook posts disparaging Turntine and Promotional Services. We got some grumpiness here in the world of darts. After these posts, Promotional Services banned Red Eye Rhino. Promotional Services banned Red Eye Rhino from participating in any of the events following the 2016 tournament. Great stuff. Roughly 2 years later, Red Eye Rhino posted to Facebook a photo taken at the 2018 tournament featuring two players who had been sponsored. When Turntine learned of this, he asked for the photos to be removed. Subsequently, defendant posted to the Facebook page comments criticizing Turntine over their business dealings going back to 2015. Yes, the dark controversy has gotten real. Turntine responded by posting a statement in his Facebook post hosting the Promotional Services, recounting the parties' past business dealings and explaining why their business relationship had soured. Bringing the drama onto Facebook. Good stuff. So here's where we get into the defamation issue. Here's where we start getting into the defamation issue. So we had some business dealings. We had some falling out. We were the exclusive provider. Now we weren't. We won $500, blah, blah, blah. So now, fast forward 3 years later to 2018, and the controversy starts getting real. All right. First, on October the 30th, 2018, defendant posted to Red Eye Rhino's Facebook page and later on its own Facebook page the following statement. There is only one league that manipulates, lies, and censors its players. Charles RER, CEO of Red Eye Rhino, speaks up about the recent attacks from Justice Turntine of the Tournament Champion League. Outstanding. These statements, along with video contained in the same post, indicate that Pearson would be broadcasting a video in November 2018 to address these statements. Great stuff. Second, on November the 18th, 2018, defendant posted a video to Charles RER Facebook page. In it, Pearson accused Turntine of selfishness and greed, and claimed that Turntine had engaged in underhanded business practices in 2015 by selling Peterson vouchers for Peterson to redistribute and then actively interfering with the ability to redistribute them. $2 from Q Squared. Kurt plays darts for charity versus Leonard livestream. If Leonard has any skill whatsoever, he'll kick my butt, but sure. Third, in the comments section of the video post, Peterson responded to 3 different individuals who had questions. One asked, I know you said that Turntine is a liar, but did he actually lie to you, or did he not just like the guy? Peterson responded, yes, he has lied about the situation to manipulate it. Another asked, what do you mean Jim Turntine lies? I don't want to be involved in a league that lies to his players. Peterson replied, he has lied about what he's saying about me to manipulate the situation. A third person asked, Jim said on Facebook that all this started when you refused to make a charity donation. Is that true? Peterson responded, no. We refused to be part of the tournament because I don't like how he does business, and I knew the BS was to come. Jim uses the Pediatric Foundation donation to gain sympathy from people about what went down. It's a complete lie. A few weeks later, Turntine and Promotional Services sued Peterson and Red Eye Rhino in Missouri State Court, bringing 2 counts for libel and 1 count for slander, in seeking in excess of $20,000 for each count, as well as punitive damages in an amount to be determined in the future. Defendant then brought the action in a federal court on diversity jurisdiction and moved to dismiss all grounds. Very exciting. Under Missouri law, the elements of defamation are publication of a defamatory statement that identifies the plaintiff, that's false, that's published with the requisite degree of fault, and damages reputation. Again, different courts have described these in slightly different words, but we all recognize this, right? This is more or less the defamation standard everywhere. It's false, it's published, it's about someone, it caused them harm. We understand this. This is pretty much defamation everywhere. The district court dismissed all accounts for failure to state a claim on the basis that the element was not satisfied due to the fact that the statements in question were not actionable because they were either not defamatory or they were opinion. Very exciting. $2 from Q Squared. Next story. Dartz versus Pac Man. Yeah. I'm also tempted on a personal note. I'm tempted very much to get into the Billy Mitchell, Pac Man, Donkey Kong lawsuit between them and Twin Galaxies and all that shit. Because that seems like some first class drama. So I may get into the Billy Mitchell thing. Because I feel like I want a piece of that. I feel like I want a piece of the King of Kong, or both actually. Yeah, that's actually because he was in a movie called King of Kong when he wasn't a fraud, and now we could make a new movie called King of Con. Trademark pending. Don't make my movie. Trademark pending. King of Con is mine. Don't use my name. First, the reviewing court must determine whether a statement is capable of defamatory meaning. A defamatory meaning is a meaning that tends to harm the reputation and lower the reputation. In determining whether the words are capable of such meaning, the court must consider them in context. Second, in statements in question are capable of such a meaning, the reviewing court must determine whether a privilege shields the defendant from legal action. The only privilege defendants argue here is one of opinion privilege. There can be no liability under state defamation law for statements of opinion. The privilege does not apply if a statement implies facts, even as couched as opinion. To determine if an opinion implies facts, the reviewing court must determine the totality of circumstances. Before applying this 2-part standard to the specifics of the claim, we must address a dispute about the correct legal standard in Missouri law. So we have to figure out what Missouri law is, because this is a Missouri cause of action, but we're not a Missouri court. We're a federal court. So we have to figure out what Missouri law is on this exact issue. The district court here identifies additional component of the analysis defendant argues applies, namely that if a statement is capable of non-defamatory meaning and can be reasonably construed in the innocent sense, it must hold it as non-actionable as a matter of law. This principle is referred to as instant construction rule. So there is some case law that exists that suggests, at least in some states, that there might be a standard that if it can be construed innocently, it must be construed innocently. So it's only if it can be construed as defamation that will bring it defamation. So if there's an in construction, it's fine. But this is the dispute as to whether or not this applies in this court or not. Dog Eat Dog asks, so when a case goes up to federal court, the state law matters, not federal law. Well, it depends what the law that is being applied here is, right? It depends which law is being applied. So it's not that simple. But the defamation is a state law claim. It's a state issue, whether or not defamation applies. So regardless of what court is applying it, the issue is state law, not federal law, because there's no federal cause of action for defamation. It's a state level claim. So the federal court is going to apply state law. So yeah, they're going to apply the state law. So it's not as simple as saying it doesn't apply. It's just that the only legal issues, well, not the only issue, but the principal legal issue here is the state level claim. So the fact that federal court is hearing it is irrelevant. The federal court still has to apply the state law because it's a state cause of action. Sure, yeah, that's how that works. What about defamation in DC? Who has jurisdiction? The state courts of DC, which, yes, do exist. So there are state courts of DC that hear state causes of action in DC. So, yes, DC has defamation law, but it exists as a matter of state law. So, yes, same analysis applies. And so, again, if a federal there are state courts in DC. So if a federal court is doing defamation, and we've seen that actually before, we saw it recently in some other cases. But yes, they would apply the state law of DC. So yes, same thing. It's a little bit weird in DC because they're not a state, but yes, it's a matter of the jurisdiction's law. There's no federal defamation law. So yes. No, not district courts. No, not district courts. They're completely separate courts. The DC still has federal district courts. So DC has federal district courts, but DC also has state trial courts, state appeal courts, and so they have all that. So yes, they are separate. They're not the district court. It's a different court. You got to make sure you're following the right one. A line of Missouri Court of Appeals decisions further supports the view that Missouri follows this innocent construction rule. So they're saying that the courts of appeal of Missouri say that there is this rule. So is it true? We recognize that in the absence of a Missouri Supreme Court precedent deciding the issue, decisions of the Missouri Court of Appeals are persuasive authority that we must follow when they're the best evidence of law. We need not follow them, however, if we're convinced that the Supreme Court of Missouri would decide otherwise. So this is some bizarro world. This is some bizarro world. So there's some decisions from the Missouri Court of Appeals, and there may or may not be decisions from the Supreme Court of Missouri. So the Missouri appeal courts are binding unless we are convinced the Missouri Supreme Court would say that's wrong. So even if the Missouri court hasn't said it's wrong, we're going to pretend that we're the Missouri Supreme Court, and if they would, then we would. You know, this is a weird operation of law, but it does happen occasionally when one state or jurisdiction is deciding the law of another state, which again occasionally happens for a whole host of reasons. You have a contract which says it's the law of one state, but you're actually in another state. So you could have state courts applying the law of another state. It happens, and then you have to put yourself in the position of the Supreme Court of that state and said, if I were the Supreme Court of that state, what decision would I reach if I were them? If I literally were them, not me in their position, but if I literally were them, what decision would they reach? So I have to reach the decision they would reach. So whole kinds of trying to figure it out. It does happen. It's cute when it does. Before 1993, Missouri courts made distinctions about per se and per quad defamation actions. A per se claim arises when they're defamatory on their face, usually relating to certain kinds of defamation that we've discussed in the past, whereas per quad is not based on the face. The innocent construction rule only applied in the per se context, and we have seen that before, yes. And a few states only apply it in that context, identifying Ohio and Illinois as states that still follow this rule. So it is a disfavored rule. It is something that is not being adopted. Missouri could do it, but it doesn't look like they have. Although confusion on this point crept in the case law later, the Missouri Supreme Court expressly rejected the instant construction rule long ago, citing a 1910 Supreme Court case from Missouri. So this court says the Missouri Supreme Court in 1910 said, "Oh, we're not going to apply the rule." So we've got authority that says this. Is that the end of it? Of course not, because the law is never that clean, right? So let's press on. Consistent with that position, the Missouri Supreme Court has also recognized that a fact question exists whenever a statement is capable of defamatory meaning, even if it is also capable of a non-defamatory meaning. So that is the typical rule. If it can be understood as defamatory, it is defamatory. So it's the exact opposite of what the other rule would imply. If it's not defamatory, it's not. It says if it is, then it is. So okay. All right. So this is the part where things get bizarro world in legal land. So we've moved from bizarro world in the world of Dartz, which is fun on its own merits. We got a dispute in the world of Dartz, which is fun. But now we've got bizarro legal world. This is so much fun legally, because this court is trying to figure out what the Missouri Supreme Court would do if it were the Missouri Supreme Court, as in the people who are there. So not in its own view as though it were the Supreme Court, but what would they do? This is the what would Jesus do equivalent of law, WWJD. Although it's more like WW Supreme Court of Missouri do. WWSMOD. So this is WWSMOD. So what would the Supreme Court of Missouri do? This is so much fun. And this is where it gets confusing, because the Supreme Court of Missouri has not been exactly clear on its own law. So we had that 1910 case. That says we are not adopting this. But let's read further. This gets so much fun. Without overruling, distinguishing, or even addressing the precedent, the Missouri Supreme Court, in a case called Walker versus Kansas, announced that in considering whether a publication is libelous per se, defamatory per se, words to be considered are actionable should be construed in their most innocent sense. So in 1966, without addressing, overruling, modifying, without even mentioning the prior case law, in 1966, the Missouri Supreme Court said they should be understood in their most literal sense, or most innocent sense. What is this now? Right? So because the Missouri Supreme Court didn't say, oh, we've reconsidered and now we're going to adopt this. It's like, precedent? What precedent? Somehow the Missouri Supreme Court apparently was not aware of its own 1910 case. That's the only conclusion we can reach. Somehow they missed that memo. And they've analyzed a new decision, and it's just like, wait, what is the law now? Because you've said one thing in 1910 and you said one thing now, and you didn't say you were overruling it. And so what is the law? Is it or isn't it? This is great. Missouri Supreme Court got sloppy, and it gets worse. Okay, here's how it gets worse. As a support for this proposition, all right, so first of all, I don't know why the Missouri Supreme Court needs support for the proposition. This is state law. The Missouri Supreme Court is the highest authority in Missouri. So the Missouri Supreme Court doesn't need support for its proposition. It can just speak on the mountain from on high, because it's the Missouri Supreme Court. It can do that. So I'm not sure why it needs support, but this is what the Missouri Supreme Court said was its rationale. I'm not sure why it needs it, but this is what it used. As support for its proposition, the Walker Court cited a case called Arbery versus Brinks, a Missouri Court of Appeals decision that itself quoted only one of its own precedents, the Court of Appeals precedent, to the effect that words should be understood and construed in their most innocent sense before they may be deemed actionable. Quoting this case from 1910. So there was another case in the Missouri Court of Appeals from 1910. Not clear if it came before or after the Supreme Court decision in 1910. Presumably before. But apparently the Missouri Court of Appeals was unaware somehow. Years later, the Missouri Court of Appeals was unaware of the Supreme Court decision from 1910. It was aware of its own decision from 1910, but somehow was unaware of the Supreme Court of Missouri's decision from 1910. And said, oh, following our own precedent, we're going to continue to do this, not realizing it had been overruled somehow. And somehow the Missouri Supreme Court also didn't figure it out. But let's press on. Okay. But this case, Kunz, was no longer good law on this point when they quoted it. Yeah, because it had been overruled by the Supreme Court, but they quoted it. And now, okay, so do you fully understand what's going on? This is great. This is so much great law. Okay, so in 1910, a court of appeals in Missouri said, we think that innocent construction law applies. And in a different unrelated case, presumably, in that same year, the Missouri Supreme Court said, we don't think it exists anymore. Now, that is the law of the land in 1910, because the Missouri Supreme Court has spoken. And that is the law of the land. Great. Now, fast forward 50 years later, and the Missouri Court of Appeals, apparently unaware of the Supreme Court's opinion, said, well, we can't find any precedent on point except for our own precedent from 1910. So we're going to quote that. And the Supreme Court of Missouri looked at that and said, oh, that sounds good. We'll do that. So It cited a proposition that was bad law because the Missouri Supreme Court itself had overruled it. But now they're saying it's good law because they apparently were unaware of their own precedent. So they have cited a proposition that cites a proposition that's bad law because of the very court that's now saying it's good law. The Missouri Supreme Court needs to learn how to Supreme Court better. Oh, what a mess. We thought the world of Dartz was a mess, but no, the Missouri Supreme Court apparently on defamation is a mess. What is the law? Well, we've cited law that's bad case law because of the very court that's now saying it's good case law without distinguishing or attempting to overrule or anything. Okay, that's a thing that's happening in Missouri. In other words, it seems that the Walker Court, which again, let me remind you, is the Supreme Court of Missouri. It seems the Walker Court, the Supreme Court of Missouri, imported the innocent construction law into Missouri law based on a repudiated decision from the Court of Appeals that conflicted with the Supreme Court's own precedent on this matter. That case isn't good law, but now it is good law because we say it's good law, and it wasn't good law because we said it wasn't good law. What is the law of Missouri? This is great. Now this poor federal court, has to figure out what the heck the law is in Missouri because the Missouri Supreme Court doesn't know how to Supreme Court. I feel for the judge on this one. This is convoluted. This is running into all kinds of logical paradoxes. It's like, what is the law? Now I have to figure out what the Missouri Supreme Court, what would Missouri Supreme Court do, taking note of the fact that they apparently don't know how to Supreme Court. Good times. The Walker Court, which again, Supreme Court of Missouri, thus introduced confusion into law about whether it applies or not because we have contradictory opinions from the Supreme Court. We have two cases that say exactly the same or the opposite thing. Good times. All right. So in this other case, the Missouri Supreme Court recognized the rule of Walker was not absolutely consistent. That's a great way of putting it. The Supreme Court of Missouri says, yeah, it's not absolutely consistent, which is a very, very, very friendly way of saying completely inconsistent. Yes, it is not absolutely consistent in so much as it is directly contradictory. Yes, it's not absolutely consistent with the standard statements other precedents for determining whether a case is per se. In that case, so okay, the Missouri Supreme Court has been alerted to the conflict. The Missouri Supreme Court has been alerted to the conflict. We're not quite sure how you missed it, but we're now telling you about the conflict. So the Missouri Supreme Court says, okay, these are not absolutely consistent with each other in so much as they directly contradict, but we're not going to say that part. What we're going to say is they're not absolutely consistent. So we're going to be charitable ourselves. Now, it's okay though. We are the Supreme Court of Missouri, so we could fix this problem. We're not sure how we created this problem, but we could fix it. So all we have to do is now clearly state what the law is. So surely we are going to do that. Surely we are going to, now being made aware of the conflict, clearly state what the law is. But then if we did that, we'd be showing that we know how to Supreme Court. And we don't know how to Supreme Court. So let's not do that. Let's do something instead. So in that case, the Missouri Supreme Court, who had the opportunity to fix all this mess, being made aware of it, decided, not to do that, and instead concluded that the standards should be read together. Okay, I don't know how you do that, but all right, great. And found that the statement was actionable no matter what standard applied. So despite the opportunity to clear up the law, it said, no, you should read them together, but they don't gel. The Supreme Court says, yes, they do. Okay. The courts are now going to try to figure out how to do that. How do we do both at the same time? I don't know, but that's now the law in Missouri. Because again, Supreme Court of Missouri. So is good faith construction the law or not? Yes. Okay, great. That's super helpful. Thank you, Supreme Court of Missouri. Given that was only applicable in the per se context, the innocent construction rule should not have survived the abrogation of the per se per quad framework and creation of a uniform framework, a point in which they've implicitly recognized. I feel for the court here. I feel for the court here and saying, yeah, it shouldn't have survived. Now, I do think the court here is actually making a legal mistake. I think they're making a legal mistake because the question is, what would Supreme Court Missouri do? The question is WWSMOD. That is the operative question here. Now, what the Supreme Court should have done is they shouldn't have allowed this to survive, but they did. So apparently, the answer to WWSMOD is, but that is the law in Missouri. So the court here is actually making a legal mistake, because the answer here the court came with is, oh, this is just not the law anymore, which is actually legally wrong. The answer is, but I do feel for them trying to apply a law, because it's like, what else can I do? But I don't know. Certify the question to Missouri, I guess. This is fun. It appears then that the law and the subsequent Court of Appeals decision following it misapplied the law. I'm not sure how that's possible. I'm not sure how it's possible to misapply the law, because it means whatever you want to be, I guess. And in turn the logic of the decision on its head, which, again, you're already there. We thought the Dart drama was the best drama, but we were wrong. The Dart drama is not the best drama. The best drama is, what the heck is the law in Missouri? And the Supreme Court, which could have fixed all this, decided not to do that, because I don't know. Okay. So now we are going to say the law is, the framework doesn't apply. We are going to do what the Missouri Supreme Court should have done, which, again, seems like a legal mistake, because that's not the legal answer. The legally correct answer is... And unfortunately, that's not what we're doing. We're going to make it up. So making up the law now, here's what we say the Missouri law is. Okay, fine. With the tables now set, we at last turn to the substance of the claims. We're going to analyze it under a legal standard that we made up, because nothing makes any sense. So Tony asked me the question, is it possible for a federal court to overrule the Supreme Court of Missouri? No, not on state law. That's exactly why I say it's wrong. A federal court, including the Supreme Court of the United States, cannot overrule a state on its state law. The Supreme Court of the state is the master of its own law. So no federal court can overrule a state on its own state law. They can say, like, it's inconsistent with federal law or inconsistent with the Constitution. They can do that. But they can't say this is not the state law. Yes, it is. The Supreme Court of Missouri gets to determine what the state law is. You can't appeal this to the U.S. Supreme Court. The U.S. Supreme Court has no jurisdiction, because the Supreme Court of the United States is bound by Missouri's law as much as anyone else. So I guess you could ask the Supreme Court to figure out what that is, and that might be entertaining. But yeah, the Supreme Court of the United States has to apply Missouri law, because Missouri is the master of its own law, even if it doesn't make any sense. These are the defamatory statements, apparently. In the first defamatory statement, defendant respond to a statement by saying the business dealings of the plaintiff manipulate and lie. In the second, Pearson expounded on previous statements by asserting how Turntime's explanation for party source businesses was not true, and the true explanation was an engaged in underhanded business. And the third, Pearson doubled down on defendant's claim the plaintiff were liars, responding to multiple individuals inquiring about Pearson's claims were just blustered by asserting what he said. Good times. The district court concluded the first statement was not defamatory as a matter of law, because it was a response to a prior post and not a statement of objective facts regarding moral character. It concluded the second statement was not actionable because it constituted mere opinion. And it concluded the third statement was not actionable because it was not capable of defamatory meaning as a matter of law, and because it constituted a subjective opinion. We disagree on all counts. So the Court of Appeals says, oh, these are defamatory statements. So we're going to grant relief. Okay, okay. First, each of the statements appears to be capable of defamatory meaning. That is, capable of a meaning that tends to harm the reputation of another, as to lower him in the estimation of the community or deter third persons from associating. Each of the defendant's statement is capable of this meaning. The first statement accused the plaintiffs of dishonesty about the reason for the party's sour business relationship. The second statement built on the first by providing specifics, that it charged with a want of integrity in their business dealings. The third statement resembled the first insofar as Peterson once again accused Turntine of being a liar and manipulator. These statements might harm plaintiff's reputation and deter third statements from dealing with it. It is borne out by the fact that one of the individuals who commented on him asked to clarify if he really meant what he said, because he didn't want to be involved with a league that lies to its players. If you ever make merchandise, it should include okay. Maybe. A lot of time I don't know what to say except to say okay. That's a reality that's now occurring. I accept your premise. I accept your premise because you're a court telling me this. I'm like, okay, good. That is now a reality I'm going to adopt. So maybe I don't know if we should adopt okay or not, but yeah. In the first statement, defendants were responding to earlier statements by the plaintiffs regarding principal business dealings and thus implying and misrepresented facts about the dealings. This implies an assertion of objective facts, that they were not telling the truth. And the second statement went even further by describing why and how, to cover up the fact they'd chosen to cheated them out of a benefit of an agreement. In the third statement, Pearson repeated his claim that Turntime was a liar and manipulator, and circumstances which include the statement were made to rebut any notion Pearson was just conveying his subjective opinion. In context, the users who had seen the videos would want to know if he meant what he said literally, or just speaking rhetorically, because he did not like Turntime. Given this opportunity to clarify his words were non-factual bluster, he instead doubled down, explaining that he meant to claim that he actually lied. Again, these alleged lies were about objectively verifiable facts, what happened between the parties that led to a souring of their relationship. As such, the statements appeared to be false, notwithstanding the court's conclusion to the contrary. For the foregoing reasons, the district court erred in concluding the plaintiff's complaint failed to state a claim for defamatory action and seeking to dismiss each of the 3 counts therein. We therefore reverse and remand for proceedings consistent with the opinion. So that is the end of the case of James Turntime versus Charles Peterson and Red Eye Rhino. In this case, we learned about 2 dramas. One drama in the world of Dartz, and an even more important drama in the world of Missouri Supreme Court, which doesn't know how to Supreme Court, and the Court of Appeals for the 8th Circuit looks at this and says, okay, we're gonna say this is the law now, and we're gonna hold it liable and actionable. So yes, this was defamation. Yes, you can get covery. We don't know what the Missouri Supreme Court was going to do, but we're just going to say this is the law now, and you can get damages. So we'll go back and get damages, presumably, and that's the end of our coverage of this case.